Welcome to TaxWit's Wealth Protection Podcast, where we demystify the legal and tax issues surrounding wealth creation and protection. The content presented in this podcast is for informational and educational purposes only. Should not be construed as legal, financial, or tax advice. While the hosts and guests may be legal professionals, they're not your legal professionals. Laws and regulations vary by jurisdiction, and the information discussed in this podcast may not be applicable to your individual circumstances. Always consult with a qualified professional for advice tailored to your unique situation. In today's episode, we're going to talk about a problem everyone will face, but no one wants to think about. That problem is what happens to your assets and your loved ones if something were to happen to you. So Whitney, many of our listeners have not met you. Would you mind giving us a brief walkthrough of your background in tax and estate planning?
Yeah, good afternoon, Ben. Thank you. So my name is Whitney Sorrell. I'm a tax lawyer, also a CPA. Worked for the IRS out of undergrad, and became a CPA. Did my MBA, and then went to law school. So working for the IRS, was a great experience. Learned tax while a revenue agent at the Internal Revenue Service, and then in law school, I went to law school to be a tax lawyer, and I never did any estate planning before then. Didn't think I was going to. Came out, worked for probably one of the best lawyers I've ever known, named Joe McKay. He was an excellent estate plan lawyer and tax lawyer. And, he did a lot of high-end estate planning for, wealthy people. So when I worked for him, I was doing research projects and planning for him for really sophisticated types of techniques. Grats and cruts and T-clats and, NIM-cruts and flip-cruts and flips and, all these acronyms, the alphabet soup of estate planning. And I didn't
What
know,
do those acronyms stand for?
well, like a charitable remainder unit trust and a family limited partnership and a net income makeup trust and,
Oh, okay.
these types of things, qualified personal residence trust. These are different types of irrevocable trusts and limited partnerships and how you combine them to do different things, and we'll talk some more about that later, but I didn't know the basic estate planning. I didn't have any idea what is a living trust or family trust or credit shelter trust. These are all the basic stuff. I didn't know anything about it, but I knew all you needed to know about the really sophisticated stuff. And then years later, I was working in-house attorney for a company. During that time period, I became involved with the National Network of Estate Planning Lawyers and then a Wealth Council. And while we were, while I was involved with those groups, and still am involved with the Wealth Council, I learned basic estate planning, A to Z, and it was the weirdest thing because once I learned the basics, it's like the whole picture turned on, and I can see everything, and it was so clear. But so that's how I got to learn estate planning. I've been practicing law now for 25 years. After 20 years, I went back and sharpened the tools. I did a LLM in tax at Boston University. It was a great program. Some of the best, tax and estate planning lawyers in the country. And that really upped my game another couple levels. And I graduated, I think, at the end of 2021. So my practice is mostly tax related. So IRS negotiations, tax court, that type of thing, tax planning, estate planning, business transactions, mergers, acquisitions, but in the estate planning world, there's basic estate planning and then there's estate tax planning. It's two different things, so not all estate planning lawyers are estate tax lawyers. And, that's a different skill. So, I have a lot of friends, estate plan lawyers around the United States and in town. And a lot of those lawyers call me when they have cases that are, bigger, clients, higher net worth clients, and have some more sophisticated needs because it does get pretty sophisticated. So, but in any case, that's my practice and that's my background.
So you said estate planning is not estate tax planning. So tax planning aside, if someone said, what is estate planning? Because I feel like that's a big question for people is what is this?
Yeah.
Could you kind of break it down for us?
Yeah. Estate planning is really, and it's kind of funny when you first get into the business and you talk about estate planning, if you're talking to a life insurance guy, estate planning is buying life insurance to get,
Yeah.
so that you have a death benefit to pay the tax. If you're talking to an investment guy, estate planning is investing the money really well so that it grows, so that you have, but that's really a financial plan. That's not estate planning. And when it comes to estate planning, why, you know, plan to have money to pay the tax. Why don't you just not pay the tax is a better way to go about it. And so from an estate tax
Is
planning,
that legal?
yeah, for sure. There's legal ways. And it's all there are different roads to get from here to the next place, and you can take the road left or taking the road right. One gets there faster. Is that legal? Sure it is. Right. So estate planning really is a couple of things in general. Forget about the estate tax planning, but it's really a plan to make sure that while you're alive, if something happens and you can't make your own decisions, there you have people in place and process in place for people to make decisions for you, and you get to pick those people as opposed to going through a conservatorship or guardianship, which is very expensive and frustrating and terrible. And when you pass away, to make sure that your estate does not have to go through a probate and avoids probate, as a private administration, and then you give your assets to the people that you want to give them to under the rules that you want to have apply. So, for example, you have kids. You die. Does your kids get $1 million as soon as they turn 18? Well, they might. Yeah, but not everyone wants that. And money is not well spent when someone just hands you $1 million. I mean, if you have money and you worked with it and grew it, invested it, you're going to spend that money differently after 5 or 10 years than you will on day one. Right. And so sometimes we'll want to make sure that our kids get our money. We'll talk about some incentive planning later, but there are ways to protect your kids from themselves, and or maybe an overzealous husband, an overbearing husband, or their creditors. What if you die, your kid gets $1 million, and their creditors go, "Great, we're hoping to sue you, but you didn't have any money, and now you do, so we'll just take your parents' $1 million." And so there's ways to protect against all that, and that's what an estate plan is.
Okay. That kind of answered the next question. I mean, the next question is, why do you need an estate plan? And
Yeah,
it seems like to avoid some pretty terrible things. Is that right?
yeah, you avoid probate, and everyone likes to do that, and you know, to make sure that you put the rules in place. If you don't have an estate
What's
plan,
so bad about probate?
yeah, you do have an estate plan. It's called probate, and the state statutes give you your own estate plan. The problem is there's unintended results. This is a fact pattern we see all the time. And someone dies, not particularly wealthy, second marriage, and they have 3 kids from their first marriage, and now they're 70, and they have a house and some money in the bank, and no estate plan. Well, what happens is you go through what's called intestate administration. So there's no estate plan. You look to the state statutes. State statutes generally say surviving spouse gets half and your kids get the other half. And so here's what happens a lot is surviving spouse lives in the house, and the house is worth $600,000, and the kids say, give us $300,000. Well, the rest of the assets in the estate were another $400,000 of investments, and so wife is going to forego $200,000 of investments, that her share, and still have to come up with another $100,000 just to keep living at the house. And sometimes they can't come up with that other $100,000.
And I mean, sometimes they're living on those funds, right? Like that's
Well,
all they have to
usually
live on.
that's all they have to live on, and they have Social Security, and wife can't buy out the kids. So you have to sell the house. Wife moves out. She goes and figures it out. And it's really a terrible situation. But we see that a lot. And that's not an uncommon scenario. We saw a case just recently. We had a case where um, mom is divorced, ex-spouse, is still here in town, and she has two kids. Mom dies, son dies 32 days after mom. Mom was pretty wealthy. She had, I think about $3 or $4 million of assets. So she didn't have an estate plan. Her estate plan is the government's statute. The government probate rules or intestate succession rules generally says, you know, have to all your kids. Well, to each of your kids, right? So her kids got half each. So it was just under $2 million each. And by the way, mom and ex-husband did not particularly care for each other, and their families very much disliked each other. So what happens is the son, who gets almost $2 million of mom's money, dies without an estate plan. And so what happens? The state statute says his children gets all of his share, but he doesn't have any children. Well, if there's no children, then it goes to his parents. Mom's dead, dad's alive. So mom's ex-husband, who she despised and despises her, got the $2 million. That happened. And you can't really do much about it. You could have if you had an estate plan, but you didn't. It's better to put your own rules in place. And these types of circumstances, there's a number of different, fact patterns that I can walk you through that have these bad results.
Yeah. And so it seems to me, as soon as you're knowledgeable enough about estate planning and how it works, the choice is obvious. But if you look at the statistics lately, I mean, recently caring.com did this study, and what they found is they found a host of reasons why people are waiting. And they found these reasons by asking them the simple question. First, they identified, from the surveys in the sample, people who don't have an estate plan. And they asked, what would motivate you just to get a will? So the most basic estate plan that you can have. And we'll talk about why that's probably not the best choice for most people. But reading it as what would motivate you to do some estate planning, these are the reasons that people gave. The first is they're waiting for a medical diagnosis or a health concern. So 41% of people say that I'm not going to do estate planning until it's clear to me that something bad might happen to me. What would be some issues that might arise, Whitney, from your perspective, if they wait that long?
That works out really good. So I have a stroke, and there's my issue. I had no warning. How many times do you get a knock on the door? Hey, by the way, tomorrow heart attack. Just letting you know. You don't get that warning. Tomorrow the truck is the proverbial truck is going to find you as you're driving home from the library. It's often too late, and you have a stroke, and then you're incapacitated, possibly, and you don't have an estate plan, and now you have a guardianship and conservatorship, very expensive and a terrible arrangement, and you no longer have capacity to execute your own estate plan. So you never will have an estate plan. That happens some of the time. And the estate plan, your healthcare powers of attorney, your durable powers of attorney, your living will, you need that in place before you have that stroke.
Before you lose capacity to put that in place,
capacity,
right?
Yeah. So that doesn't always work out, but you're right. That's a lot of times when people walk in my office, they say, "Gosh, we just got diagnosed of early onset Alzheimer's, and so we want to talk to you about estate planning." Well, not the best way to meet someone, but that's how we meet people sometimes.
Yeah, and I do recall from my time at the firm, a couple scenarios where it's a rush job because they're literally in the hospital, and sometimes in hospice, and it just seems what a terrible time to have to make these types of decisions. I mean,
Yeah, every estate plan lawyer eventually one day is going to have that day where drive on down to the hospital and sign the estate plan with the client lying on their deathbed. And it's a very strange thing to do, not my favorite thing to do as a lawyer, but every lawyer is going to have that time, and that happens. I think I've had three um, of those occasions, so not a lot. And I think the last time, the fourth time, instead of me going down, we had I guess it was during COVID, so we had to have a mobile notary and some people that went down and like some certified fiduciaries went down and signed it with them. But and it's not really fun for the client's family members either. You know, there's some other legal issues that come up when you're doing that. Is there lack of capacity? What kind of medications is this person on? Can we even, can they get off the medications if they are on medications? Sometimes they're on pain medications, and those could potentially cause them to not have capacity. So there's issues from signing the estate plan in that way. That's not the ideal way.
yeah. So the medical diagnosis health concern being a motivator for people to getting a will, that was 41%. So that was the largest of the reasons. But there are a couple more reasons here that I found interesting. 24% of people said that nothing would motivate them. So I assume those are not the people listening to this podcast. So we'll move on.
Those are the people that die intestate and their wife has to move out of the house and doesn't know what to do now.
Exactly. And so
16% I'll tell you what, those people, there's a lot of people that walk in my office, and maybe this one's on your list. There's a lot of people that walk in my office and they say, we just got done administering my mom's or my grandmother's estate. She didn't have a will. It was a total nightmare. It took years and years. So much money went to other people other than the beneficiaries. I'm here because I don't want to leave that for my kids.
You're spot on. I mean, that was the next one on the list was,
okay.
16% of people are waiting for the death of a loved one to put a plan in place. But just like you just pointed out, that's a problem because that doesn't allow for any planning for that loved one. And it's too late to plan for that loved one when they passed away. Granted, the survey was asking them, so I guess it is a fair response. Moving on, though.
Yeah, when you're dead, you're dead. So a friend of mine, a great lawyer up in Oregon, I had dinner with time. We were talking about these issues, and she said, look, Whitney, there's one rule that always applies to everyone. When you're dead, you're dead. You can't do stuff, when you're dead. Heard about a guy a couple thousand years ago that came back after he died to clean up some family business. None of my clients have done that. So when you're dead, you're dead. Kind of hard to do things.
Yeah. Well, so the opposite side of the coin, moving away from death, 20% of people are waiting for family expansion. So I assume this is, getting married or having kids probably fall under family expansion.
Yeah. Okay.
That's logical, right?
Yeah. And, some people come in my office and maybe for something different. And so I'm talking to them about, some other legal issue. They're starting a business and it's a husband and wife. And, one of them works somewhere. The other one is forming a business and they're, building that business. And then they ask me about estate planning. And, usually I tell them, look, if you have assets, so when, depending on the state in which you live. So I think in Arizona, if you have $100,000 of real property and $75,000 of tangible personal property, then you can transfer that property through what's called a small estate affidavit. But if you have more than that, those assets, then you're going to go through a probate. And, when we have a a client, a young couple, and they don't have a lot of assets yet, and they're working. Should they do an estate plan? Yeah, it probably would be helpful just in case. You never know what's going to happen. I'm not, pushing them. Oh my God, you got to go have an estate plan now. I mean, I think there's those scare tactics that some lawyers or non-lawyer estate planning services use. But once we have a kid on the ground, that's time to get an estate plan. Once you have a kid, two legs on the ground, you need to put something in place, especially, if you're married, and you have people that are depending on you, that's the time.
That makes a lot of sense. The last few reasons are waiting to buy a home, waiting for retirement, or because it's some employer benefit. So, I mean, the employer benefit question, I don't think we really need to spend any time on that. They want their employer to pay for a portion of their estate plan.
Yeah. Well, let's talk about that quickly.
Okay.
Um, so early in my career, I had a partner that brought that to the firm and said, "Hey, look, let's be part of this." I think it was Hyatt Plan, and there was another one. I can't remember what the other one was. And so early in my career, I had a partner that brought that to the firm and said, "Hey, look, let's be part of this." I think it was Hyatt Plan, and there was another one. I can't remember what the other one was. And these like the employer, buy employers buy these plans, and they give these benefits to their employees. And the difficult thing that we had with those clients is they would come in my office and they would say, "Here's what we want to do," and I would say, "Okay, well, you need A, B, C, and D to do those things. Your employer plan pays for A, so B, C, and D, you're either not going to get it and you're not going to get the results that you want, or you're going to have to pay out of pocket." And so I think
Mhm.
a lot of times when people have these employer plans and they're going to go get their estate plan through their employer, program, they don't get what they think they're going to get through that. One of my first associates, he he worked for a law firm that did quite a bit of that work. And he'd come in and he said, I have, when he interviewed with me, "I've done more estate plans than anyone else in my law school class," and he had done thousands of estate plans. Well, they did a basic will, and it was the same document. They you know cut and pasted and replaced the people's names, dates of birth, and that was it, and printed. And that's about what you're getting with some of those employer plans. They just don't pay for much. And so you're going to get that basic, short form deal that's a standard form, and they're going to put your name on a piece of paper, and that's what you get.
Yeah. So it sounds like the problem with the employer benefit issue is you're either going to get pigeonholed by the employer benefit into doing not enough planning, or you're going to be paying out of pocket to actually get what you actually need. Is that right?
And that's what most of them ended up doing.
Okay.
Yeah. So what were the other ones you were
So
talking about?
the other one's purchasing a home. So I'm waiting until I buy a
Hmm.
home to do some estate planning.
Yeah, I don't know if why that's a triggering event, but okay.
I
Look,
mean, they
I got
probably
to
feel
tell you
it's a
something.
substantial asset, even though it's like you have a loan against this house, you have a mortgage against this house, so it's probably not an asset quite yet.
You're
But it
right.
makes you feel that way, and so you're like, oh,
Right.
I'm a
Yeah.
hotshot now. I need an estate plan.
That
I don't know.
it doesn't resonate with me as something I should wait for, and that's the thing. It's really more about where you are in life and who's depending on you and what kind of assets that you have. And once you have any amount of assets, you should probably have an estate plan, especially if you have someone that's depending on you.
What
So
do you think? What do you think that amount is
uh you know
in today's economy?
kind of depends on your situation. If you have a second wife, well, that amount is anything.
Okay.
You probably need to have a estate plan, because your second wife is, if you don't have an estate plan, she's going to be surprised at how things work. But look, here's the thing: get it done before you get sick or die. Now, what you need to do is look at your calendar, look at the date that says today's the day that I'm going to get sick, or maybe there's a day on your calendar that says today's the day I'm going to die, and get it done before then. If you don't know when that day is, you should probably go and take care of something. I mean, it's just responsible.
Yeah,
Some people have a little different sense of responsibility, right?
definitely. So that covers the last reason that people gave, which is they're waiting for retirement or some age milestone. And clearly, you don't know if the date that you're gonna pass away is on that calendar before your age milestone or your retirement date. Okay, so it's clear for a host of reasons estate planning is a good idea. But once you've decided, hey, I'm gonna prepare an estate plan, what are your options? What do you do?
Yeah, well, what do people do? They call a lawyer. They go to their financial planner. Their CPA, gives them some advice or has a standard form. They go on the internet and they find these, terrible internet options from non-lawyers who, hey, we have documents that were prepared by a lawyer. Um, but go find yourself a lawyer. What happens a lot of times is you have a financial planner. So financial planners, let's talk about the financial planner option. We
Okay.
see a lot of this. So not in all states does this happen as much as some others. Arizona is a terrible one because Arizona rarely it enforces the unauthorized practice of law rule. And so you got these financial planners and CPAs out there handing out standard forms that they got off the internet or they got from some standard form company, and they put your name on it and hand it to you. And they're going to charge you, don't pay a lawyer, a bunch of money. I'm just going to charge you $9.95. Okay, for $995, you got, these pieces of paper with your name on it. One says will at the top, the other one says trust at the top. They have no idea what the documents say, and that's what you get for $9.95. And so, someone asked me one time. I'll tell you about. I was talking to a guy once, a CPA. He was at a friend's holiday party, and I'm getting something, bite to eat, and he says to me, "Hey, so what do you do?" And I said, "Well, we do a lot of estate planning and tax work." And he says, "Oh, I do some estate planning too." And I'm like, "You're a CPA?" He goes, "Yeah, well, we have a trust, booklet that, this stuff was prepared by lawyers, and it was prepared by a lawyer in California who's not wasn't barred actually, and he drafted a bunch of stuff for a company that sold them for the purpose of selling them to non-lawyers for this purpose. And so you see these financial planners that have these things. And so I said to him, at that time it was right about the time when the President Bush, the repeal of estate taxes repeal. It was kind of that time, and so when you draft a trust and you're a married person, you have this funding formula that sends the assets part to a family trust or a survivor trust gets half, and then the decedent's assets go half to a family trust or a bypass, or we call the marital trust. Some people call the marital trust the Q-tip trust. The family trust is sometimes called the bypass trust or the credit shelter trust. They have these different names. And so, but you have this funding formula that does this. And so I asked the guy, I said, so what kind of funding formula are you using now that we have estate tax repeal? Do you use a fractional formula or a pecuniary formula or a Clayton language, formula, maybe a disclaimer formula? And the guy says, oh, no, we don't do any of that. We just have an AB trust. And I went, that means you have a formula. You just don't know what it is. You have no
Yeah,
idea what you're
that's
doing.
concerning.
You have no
Yeah.
idea what your documents say, and you're just handing out some paper. And so, look, clients ask me, so is that, hey, I got my estate plan at LegalZoom, which is one of the worst options possible. Uh, it's really, really bad. It's shameful.
Yeah,
Um,
I'm glad you brought that up, Whitney, actually, because before our conversation, I knew that it would go in the area of online estate planning and why that's so terrible. So I looked at I pulled up the terms of service for like the two major online estate planners in my mind, which is LegalZoom, and then more recently, we have Trust and Will, which is just kind of exploding. How different are their terms of service? Because Trust and Will has a really good marketing team, and I mean, they make a compelling argument for why you should use them for estate planning, but you find the exact same issue. So with LegalZoom, their terms of service say if you use LegalZoom, you agree to this paragraph, and it says, "I understand and agree that LegalZoom is not a law firm or an attorney, may not perform services performed by an attorney, and its forms or templates are not a substitute for the advice or services of an attorney." So right there, they're saying we're taking a standard form. They're implying, hey, we might customize it based on the information you give us by the, based on the questions we ask you in this online system, but we don't replace an attorney. You probably, I mean, it's implied you probably still need legal advice for this to work out the way you want it. And so if you look at Trust and Will's terms of service, it's almost the exact same. They go as far as to say that they strive to ensure that its automated services are complete, but they're meant purely as self-help forms. The materials and services are not substitutes for the advice of an attorney. So it's buried on their website, and they're required to say it, but they're required to say it for a reason, because they know that some percentage of their estate plans will not pass muster. Is that right, Whitney?
Yeah, like almost all of them. So those two choices are some of the worst choices that you could possibly make. Sometimes not better than having nothing. So a client once asked me, "Hey, look, what if I go to LegalZoom?" And I said, "Look, why don't instead of spending whatever LegalZoom's gonna charge you, go down to Office Max, and I think on aisle 12 it is. Last I was there, there's they have a little section with some legal forms, and there's like their trust in a box, and they had it was $29.95, literally $29.95 for their trust in a box. So I said, go down for $29.95 instead of spending $400 or $300 or whatever the cheap online service is charging you. So go spend $29.95 and just fill out the trust in the box." And they looked at me and they said, "Really? Does that work?" I said, "No, it doesn't work, but at least you only spent $29.95. Why are you going to spend $300 or $400 when you can spend $29.95 and get the same thing?"
Yeah. If it's not going to work, then just don't do it. Yeah.
Well, if you're going to waste some money, waste less, right? Just
Definitely.
saying.
Okay, so online estate planning options, no good. Financial planners offering to do estate planning for you.
The same thing. What they're selling isn't exactly the same thing. So there's a couple of companies that provide these standard form trust books. The financial plan. This is literally what's happening. The financial planner gets or sometimes CPAs do this too, but not as often. So the financial planner gets you fill out some basic information, what's your name and who your kids and how old are they, are you married, and they fill out this basic information online, and they pay like $199, and they send it off to this company. The company then ships them a standard form, estate plan that is basically the same for every single client, except for the names are different and the dates of birth are different, and your wedding date is customized. That's their customization. We got your wedding date on there, not someone else's wedding date, and then they hand that to you and they sell it to you for $695 or $995 or $795. They're making money on you. They literally are paying these online companies like $199, and they're reselling them to you for whatever, and they're doing that so that you don't go talk to a lawyer, because when you go talk to a lawyer, the lawyer is going to explain some things to you, and some of those things might interfere with that financial planner getting their commissions. And they don't want that. They want to control you and keep you inside their office and, hey, we're the one-stop shop. right? And we'll do it all right here. And then they, maybe have someone that'll do your tax return too. So
Right.
that
And I want to be clear, this isn't a
unauthorized practice of law.
condemnation on financial planning as an industry by any means, but what you're saying is that there's some bad actors here.
Well, those that are engaging in the unauthorized practice of law, it's a condemnation of them, for sure.
Right.
And
Okay.
there's a lot of them in Arizona. It's rampant. So, look, a lot of estate plan lawyers, they have all these financial planner friends and all these relationships with financial planners. And that's a better way to go. If your financial planner is going to say, hey, I'm going to refer you to a lawyer, their office is over there, and go meet with them. Great. When that lawyer is in the financial planner's office, you're getting not probably something you're going to end up liking. But so when they're sending you to an actual law firm who has a separate law firm office and they practice law, and they're going to go through and build your estate plan, then that's really what you're hoping to find. But a lot of those financial planners, they're, like I said, that's the unauthorized practice of law, and they're going to try and keep it in house. So what happens sometimes is financial planner, they're trying to get those annuities and the life insurance sales, and I don't have relationships with them because the financial planners, they use the lawyer to get some credibility to make their sale. And so I just didn't like that. Half the time when they would bring me into a client matter, the client had no idea what was going on and why did they need to talk to me, and I didn't know why they needed to talk to me either. And it was really, they were just trying to build their own credibility, that say, hey, we have a relationship with the lawyer. So I stopped that. I don't really have a lot of relationships with financial planners, just like a couple that I really like. They're really good at what they do, and they let me do my job and I let them do their job. Um, so that's the relationship that I have. So I have relationships with more CPAs because, CPAs, they're really built for what's in the best interest of the client, and they're a lot more conservative, and I think that they really have a different eye towards what's in the best interest of the client, whereas the financial planners, they seem to be there seem to be quite a few of them, not all of them, but there seems to be quite a few of them that really are there to get their commission. And so those that I had a relationship with, what would happen a lot of times is they would go out and they would sell them a whole bunch of life insurance, and then bring them to me and then say, okay, we already did this. And I would say, well, wait, why did you build this type of life insurance and own it that way? Because life insurance is good. I like life insurance. Let me build life insurance into the plan. And they shouldn't have bought that type. They should have bought a different type, and they should have owned it this different way. And that would have worked out better. But what you've just done is you've created a bigger tax problem for them, and so they're going to be paying more money for less death benefit, is what happens a lot of times. And the financial planners, they don't like that, because I'm going to cut down on their commission, because I'm going to give them some good idea, the clients good ideas of how to get more out of their life insurance structure. And so I should be the one that helps show the client, here's where life insurance fits into your plan. And I like life insurance, honestly. And when it comes to it, if you're young, whole life insurance, it's the most expensive one, but you get more. You pay more, but you get more, and there's a lot more uses for it. When you're older, it's probably too expensive, but we can show how to build the policies into the plan. Maybe we're going to have that in a life insurance trust. So here's what happens a lot of times: we'll have a whole life policy, a smaller whole life policy owned by the client, and that's something that they're going to build cash value. And there's a lot of benefits while you're alive that you're going to get from your whole life insurance policy. And there's a lot of reasons why you should build a whole life insurance policy that builds cash value. But the term policy, or the universal life, that's built to not build a lot of cash value, but to have a lower annual cost, the annual premium, that's the policy. You have a high death benefit, and you put that in the life insurance trust. So when you die, it's not part of your taxable estate. right? I've seen these planners. They'll bring it to me, and we have a client who has a taxable estate. And so that what they did is they sold them, hey, you're going to have to pay $1 million in taxes when you die. So let's buy $1 million of life insurance. But they own it. So now they're going to have to pay another $450,000 for the estate taxes on that life insurance because you owned it at your death, you know? So you got to not own it if you don't want to pay estate taxes on it. So why are we paying more money for, $1 million policy when your kids are only going to get $550,000 of that policy? Buy a $550,000 policy, own it in a life insurance trust, and pay half the amount of annual premium, and that's a better deal. And of course, it gets the financial planner a smaller commission, and they don't like that.
Okay, so
I'm going to get a bunch of hate mail after this podcast from financial planners.
it's clear that using an attorney is the best choice.
Yeah. So, and let's talk about that. So a lot of lawyers do estate plans. And there's not very many lawyers. I sadly to say, I would say probably 10 or 15% of the lawyers that are doing estate plans really know what they're doing. And the other 85% are, bankruptcy lawyers or personal injury lawyers that thought, hey, look, I got some standard form books and I can sell some paper. Look, that's some expensive paper. You shouldn't pay $1,000 or $2,000 or $3,000 for some paper, and that's really what you're getting with your name on it. So there are some lawyers, and this is how you're going to know when you go to a lawyer that knows what they're doing. They're going to sit down and they're going to ask you some questions. Is this the Brady Bunch, or is this the Ward and June Cleaver family, right? And if we're the nuclear family, I'm going to draft that estate plan differently than if we're the Brady Bunch, because when we have a blended family, there's a whole host of issues that arise, and I'm actually going to draft the underground, the basis, the structure of that estate plan differently. Do I have minor kids? Do I not? Well, I can tell you, when I have minor kids, we're gonna talk about that. And there's a lot of things that we'll do for incentive types of planning. Like I said, you hand a kid $1 million at the age of 18, they're going to spend it differently, and you can instead hold it in a trust that says, we're going to pay if you're going to go to college. We're going to, help you out. If you're not going to college, go to work, and we'll, pay you a percentage of your adjusted gross income. Go be a contributing member of society. Don't sit around smoking some weed, waiting for us to die, and then spend it all in 18 months. I think the national average is about 14 months. And you spend it all in 14 months, and then you don't have any skills or money. And so there's a lot of things that we would do when we have now. What if we have kids that are disparate age? So I had a couple of kids, then I got divorced, I got remarried, had another kid. My youngest kid is 7, and my older kids are 22 and 24. Well, you know what? I die in 10 years, and my youngest kid is 17, and my other kids are 31 and 34. Is equal fair? Well, let's talk about that. I have $3 million. Each kid gets $1 million. Well, the 17-year-old, they're going to spend half of that money paying for their own care, paying for their first car, paying for their wedding, paying for themselves to go to college. And I paid for all of those things for my older 2 kids. So equal really isn't fair. So a lot of times what we'll do is we'll do what we call an education support trust. We do, some people call it a common pot trust. We want to simulate that I live to expectancy. So, we don't anticipate dad's going to die at a young age and we're going to get all their money when we're young. We certainly hope that doesn't happen. And we hope our dad lives, to a regular, age. And so we're going to simulate that. So we're going to say, hey, let's hold all the money and spend it as if dad were still alive. What would dad spend the money on? Well, dad's going to help his kids the way they do. And some parents pay for more and less than others, but I'm going to help my kid get a car and go to college and, down payment on the first house and pay for the wedding. And, maybe they move back into the house for a year or two for whatever reason, and then they move, out again. That happens all the time. And
But you're saying
um,
whatever it is, whatever the arrangement is, this way with the common pot trust, dad can put those decisions in writing for what he is and isn't willing to pay for right
right.
there in the trust. So that even if he does pass away, it simulates
And
as
then
if,
when the kid gets to be 25 years old or graduates from college, whatever happens first, then a third. And that's a more fair way to send the money out, as opposed to, especially when you have disparate age. But this is just one way that, you're going to look at those circumstances and you're going to draft that trust differently. You know, we might have incentive provisions to that, and this is something that not all lawyers do. And I don't know why, but when we do estate planning, we generally leave, and when we have young kids, most clients, especially that have any wealth, they want to have some incentives in their estate plan. They want to pass their values along with their money. It's easy to give your money, your kids die, most likely they're going to get it, but you want to pass your values along with that. And you don't know who's going to be raising your kids when you die, if they're young, right? So you don't know how they're going to turn out. And so there's incentive types of provisions. There's a whole host of how that might work out. But we
yeah.
can,
So before you kind of get too far down that road, I just wanted to ask you, because you mentioned that a large percentage of estate planning attorneys might not be as quite as competent as they lead on. If I'm in the market and I'm trying to get some estate planning done, what questions can I ask in a consultation to kind of ascertain, is this a more experienced planner? Can they handle my situation? Like, what types of qualifying questions might you ask an estate planning attorney?
that's a good question. That's a good question. I'd ask them, what kind of funding formula do you use in your estate plan? If they don't know how to answer that question, then you need to get a different lawyer.
Yeah,
And
and I
the
was just
answer,
thinking from the customer's perspective, you're not going to know what the right answer is, but
no,
it has to do with how they deliver the answer.
that's right. You don't have to know anything more than ask the question. And if they don't know what you're talking about, then they don't understand. So if you're a blended family, there's a different funding formula I would use than if you are the Warden, June, Beaver, Cleaver family. And if you're the Warden, June, Beaver, Cleaver family, if you have $1 million or $2 million, there's a different formula that I would use. And then if you have $6 or $10 million, you know, and so I would use I use probably three different formulas, maybe four on a regular basis, and it has everything to do with what that client profile looks like. And so if the estate plan lawyer knows what he's doing, he'll tell you it depends. And I'll use a fractional formula in this circumstance. I'll use a altamarital. So that now with the estate tax amounts so high, you know, we use a different formula than we did before generally. And if lawyers haven't changed the funding formula that they use over the past several years, they don't know what they're doing. They're just handing you the standard form. But some lawyers can actually, like, I can draft a trust from scratch because I know what every article of the trust does and three different ways that we might draft that article. And you need to find yourself a lawyer that understands that understands how differently you might draft articles 1 through 14 or however many there are in their trust, based on the profile of the client. So I would ask them, what's the funding formula? I would ask them, how long have you been doing this? I would see what is their process. So the process, so they're on the Wealth Council listserv, there was a discussion kind of going on for about the last month, and different lawyers talking about their process. Do we have a one meeting, two meeting, three meeting, four meeting process? What's that mean? So when in my office, when we have a very holistic approach to estate planning, and there's a lot of good lawyers that do that. I'm not the only one in town that does. And so what that means is, so I might have an initial consult with the client, and I'll sit down. They'll tell me what they're trying to accomplish. I'll ask them some questions. They say, yes, we like you. We want you to be our estate plan lawyer. I'll hand them a booklet that kind of walks them through some questions and some, asks for some basic information, So, of course, we need the basic information: name, address, phone number, where you're born, were you married before, do you have kids outside the marriage, do we not, kids' names and ages and different things. But then there's a series of questions, that we'll ask, is probably about 25 or 30. Are you concerned about this? Are you concerned about that? Are you concerned about the other thing? And that will kind of give us some indications about, what really is motivating the client, right? Then the client will come back for their first design meeting. So we'll have a series of design meetings. If that lawyer is not going to walk you through a series of design, even if it's one design meeting, and sometimes it only needs to be one design meeting. And so in that design meeting, we're going to talk about the different parts of the trust and 2 or 3 different ways we might draft those provisions, and ask them, what do you want? So clients sometimes walk in my office and they'll say, hey, we have an estate plan. Here it is. It was done, about 6 or 8 years ago. What's it? Explain this to us. And I'll ask them, well, what were your instructions to your attorney? What did you tell them? How did you tell them how to draft it? And they'll say, well, we just gave him some basic information and he handed us a trust and we signed it. Well, okay, that's the attorney you don't want. You do not want that guy. You want the guy that's going to walk you through a design meeting or more. And during that design meeting, the first easy question I'm going to tell you is, hey, someday we're going to have to decide whether or not you're incapacitated. Most standard form trusts say, if 2 doctors agree, you're incapacitated. Well, a lot of clients don't like that because doctors don't want to sign these notes, by the way. So it's hard to get them to sign it. Usually you have one doctor that knows of your, condition. And the first one isn't so bad, but to get the second one is hard. Heck, I broke my foot in a karate tournament, and the next day, I'm jumping around on one foot. And the next day, I'm trying to get an appointment for a doctor, and they're like, yeah, we can make an appointment with you a week from Thursday. I'm like, my foot's broken today. I need an appointment right now. Getting in to see the doctor isn't the easiest thing all the time. And then if your mind isn't all there, let me tell you, the last thing you want to do is have your family drag you around to a bunch of doctor's offices asking you questions. What did you have for breakfast yesterday? And who's the president? And, things like that. And that's the last thing you want to do. I'm going to tell you, I had a client that came in and she said, yes, so we were down because they were trying to make sure she had capacity or didn't. If she didn't, then they could exercise, the powers of attorney, because powers of attorney don't really pop into place until the person lacks capacity. If the person doesn't lack capacity, then, that person can sign estate planning documents. If she doesn't have capacity, then she can't sign estate planning documents. So she's down at the doctor's office, and it was one of these offices, that's like probably was a house, but they have, the patio doors, in the offices, right? The little quaint downtown areas. And so they're down there, and the doctor's outside the room, the examination room, and doctor's outside the room talking to the daughter, and they're talking about what's going on, and she's telling her, about the things that are going on at home, why they're concerned and stuff. And so they're having 10-minute conversation. The doctor goes in. The woman wasn't there. She opened up one of those doors and she left. And they found her. And there was a bus stop down the street. She got on a bus. They found her 2 days later across town at another bus stop. They had a police officer found her and brought her home. It was scary, first of all, but the point is, this is the last thing that you want, is to have your family, showing you around town, that bringing you to different doctor's offices, asking you, what'd you have for breakfast and who's the president, So, any case, that happens. So I'm going to sit down with my client and I'm going to say, do you want 2 doctors to agree? Do you want maybe one doctor agree and your spouse? How about a disability panel? So there's a thing called a disability panel. Um, my disability panel are my three kids and my wife, and my mom, if she's alive and has capacity. So that's my disability panel. Majority vote of my disability panel says that I'm out of my tree. They take the keys away from me, and I'm deemed incapacitated. Have a private determination. They're not trouncing me around to doctor's offices. And a lot of clients like that. A lot of clients like the private determination. So the point is, all of the different pieces of the trust, there's different ways to skin that cat, right? There's different ways to solve the problems. And your lawyer should know a couple of different ways and walk you through a design process and ask you, do you like this, that, or the other thing? What fits you and your family better? And you say, hey, we like, A, B, or C. We like B. Let's go with B. Okay, great. And so if you find a lawyer that understands this stuff enough, they're going to have a design meeting or two, and they're going to walk you through the estate plan and tell you, here's 3 different ways that we might do it. Which one do you like? That's the attorney that you want.
Okay. That makes a lot of sense. So they need to be asking you, their process needs to allow for them to customize the trust to the extent that you just described. Otherwise, you're probably working with someone
Otherwise,
with
you're
the
getting a standard
form.
form. Right. I always tell my clients that when I'm done with your estate plan, you should be able to hand 5 different trusts booklets to your mom. And your mom could look at all 5 and say, this one's you. I can tell. I can tell by the way it reads. This one is you. And that's when you really have a lawyer that knows how to customize the estate planning to you.
Okay, so I think a good way to kind of wrap up our discussion here is to talk about the difference between living trust planning. Well, let's start from the very bottom. What's the difference between a will-based plan, a trust-based plan, and then some more advanced planning tactics?
Yeah. So a will-based plan, you have a will, last will and testament. And, when I was a kid, Howard Hughes died, and everyone came out of the woodwork with their, will. Hey, the server at Let's Eat, the Big Apple, and he gave her a will because he liked her a lot. And the gas station attendant on Route 66 had a will. And there was, I think, like 17 people that came out with their will. I think like 12 people actually got their $1 million. I have a will that says I get $1 million. I think 12 actually got it. Well, the will is kind of the side event. The will, if you have a will-based plan, here's what's going to happen. For sure, you go to court and you probate the will. You're in probate for sure. And that's what you're doing when you go to probate. You're proving the will. And so if you have a will-based plan, for sure, you're going to be in probate. If you have a living trust, you're going to be able to avoid probate. But the living trust has to be funded. What's that mean? Living trust should have legal title to your assets so that when you die, legal titles in your trust, your trustee over your trust can go ahead and administer your assets. If you have assets outside your trust, I think we talked earlier, in Arizona, every state's different. So in Arizona, $100,000 of real property, $75,000 of tangible personal property. If it's more than that, then for sure you have to go to probate. So people say, hey, I have a living trust. I signed it. Now I don't have to do anything. And when I die, no one has to do anything. Well, no, you have to do some things. But first of all, your living trust might not be helping you because your living trust actually does things while you're alive. If you are incapacitated and you have a trust and your trust has legal title to your assets, then you don't have a conservatorship and guardianship because the trustee of your trust can go ahead and administer those assets for your benefit. The trust is working for you while you're alive. I always tell clients, look, I have a suitcase and I put my suitcase in my car. I drive to San Diego. I get to the catamaran. I get up to the penthouse suite and I pull my suitcase out and I open it up and there's nothing in it. the suitcase didn't work. You got to put some stuff in it first. And the same thing with your trust. You got to put some stuff in it. And so as long as you put your assets in your trust, then it's going to start working for you. So a trust-based plan is going to avoid probate if it has legal title to your assets, and then it's going to do the things and carry out the instructions that you put in place. Hopefully you got one that you gave the instructions instead of the standard form. And then we have some advanced planning. So advanced planning, I don't know how much we're going to talk about that, but we have clients that come in and they have a taxable estate. This is a wealthy client, and when they die, there's going to be an estate tax. Well, honestly, estate taxes are voluntary. You volunteer to pay them because you didn't hire a tax lawyer that knows how to not pay taxes, estate taxes, when you die. There's a lot of ways that you can not pay an estate tax when you die. Honestly, let's say at the very moment, you can give about $13 million without paying an estate tax. So husband and wife can give $26 million. Well, great. And so so two things: if we're over that or under that. If we're under that and we only have $4 million, which is a good sum of money and a very successful family, well, we're not going to have an estate tax problem. Well, you won't, but you might have an income tax problem, because the way a trust works, if you don't have the right funding formula, mom dies, and then 10 years later, dad dies. Usually it's the other way around. The assets have appreciated over that 10-year period. And all of that appreciation half of that appreciation is going to be taxed at income tax rates to the kids when dad dies, or the second spouse. And just because we used the wrong funding formula. If you use the right funding formula, at the second death, everything gets a step up in basis. There's no estate taxes. There's no income taxes, right? And so it does matter what the funding formula you use. It matters. If you have a taxable estate, and so today it's $13 million. In 2026, January 1st, that $13 million a piece goes away, and it goes to half that. It's indexed for inflation, so it'll end up being about $6.5 million. Unless there's some changes to estate tax laws, which depending on who's controlling Congress and the executive branch, there could be changes.
Are you saying that if you pass away on January 1st of 2024,
2026,
2026,
yeah.
Okay.
So January 1st, 2026, the amount is 6.5, not 13 million. So
is that a game you play? Because you're not going to know when your clients are going to pass away. Obviously.
Yeah, you really don't. And so we plan for the laws that are in place. We can't plan for a law that we think might change, but we plan for the laws that are in place. And we know that the laws are going to drop to $6.5 million in 2026. We hope we're going to survive that period of time. And so we generally plan for a $6.5 million lifetime exemption, is what it's called. So
for estate tax planning.
Yeah, for estate tax planning. I had a client, net worth about $75 million. The clients were relatively young. We put together a plan, and so how you hold title to assets changes how the IRS views the value of that asset. So I can have a $10 million asset, and the IRS will look at it and say, I see $4 million. Okay, well, gosh, if I can give 6.5, I had 10 million, but the IRS only sees 4 million. I still got another $2.5 million I can give, right? I had a client that under the $13 million each, they had a $75 million estate, and we got them to a zero estate tax. Now, of course, when the estate tax laws drop down to $6.5 million, that's going to cause them to pay estate taxes on about $13 million, because there will be some more taxable estate there. But the point is, there's a lot of things you can do. It all depends on how you own the asset, the way you title it. There's different types of trusts right out of the Internal Revenue Code. The Internal Revenue Code says if you hold the asset in this type of trust, for this period of time, then we're going to pretend that $10 million is $6 million or $4 million or $1 million or whatever it is. And so there's ways to use the law legally and not pay tax. You got to be super wealthy to really pay an estate tax if you have a good tax lawyer. Is a true story.
So the shift in focus really between like a will-based plan, a living trust-based plan, and advanced planning is will-based plans really are never a good idea because you're going to have to go through probate anyway. Living trusts give you a lot more upfront decision-making capability and lower cost and hassle for the people who actually end up administering your estate, gathering the assets, paying the creditors, that sort of thing, before, distributing the funds to the rightful heirs. And then advanced planning is advanced because you need it, because you have a substantial net worth or you have some other concern. Is there any other reason why you'd advance plan other than estate tax planning?
Yeah. So asset protection planning is the other reason. So I die, my kids, you get a third at the age of 20, 30, and 40. You get some standard form, that says that. Okay, so my kids all get my money and they all get, $2 million a piece. And you know what? One kid was in a divorce and the other kid was in a bankruptcy and the other kid has IRS problems. And as soon as they inherit my money, they got creditors that are waiting there going, great. Bankruptcy estate says, hold on a second, you just inherited $2 million. We'll pay all your creditors off with that. You don't need to discharge your bankruptcy. You can just pay all your creditors. And the IRS says, great, you just inherited $2 million. We'll take that. Thank you very much. That'll pay all your taxes. And so there's no defending against the IRS. You're in a lawsuit for whatever reason. That is all subject, to your creditors. Any inheritance is subject to all your creditors, however they might come. But if I prepare an estate plan and I do it correctly, then and I rarely, when I review other people's estate plans, I rarely see it. I would say 1 out of 25 estate plans I look at have it drafted this way. But when you pass your assets to your kids, you can do it so that it will not be subject to any of your kids' creditors, and your kids can even have control over it. If you want to say, well, I want my kids to have control. All right, they can do whatever they want with it. So long as it's owned in this trust that I leave for the kid, they can have full discretion to do whatever they like. But you know what? The only difference of it being in their own bank account is no one can take it from them. Who wouldn't want that? Everyone would choose to have it that way as opposed to a different way. And we can talk about, so estate planning, asset protection planning is a pretty big body of law and various techniques. And we could talk about that for an hour. Another thing that people should know about is qualified plans. Qualified plans are a special asset. They're referred to as an IRD asset. Income with respect of decedent is what that means. They transfer differently. They're taxed differently than other assets at death. And there's a lot of rules for what happens after someone dies. And it kind of depends on how old you are when you die.
And that's like you're talking about like an IRA or like a 401k,
IRA,
things like that.
401k plan, 453B plan, 403B plan, those TIAs, those qualified plans, right? And so there's a lot of, I think, bad information and misinformation and half information out there. There's some complex rules. The rules were just changed again just recently. And so if you died in 2019 or if you died in 2020, there's a different rule that's going to apply. The 2020 rule is definitely not as good as the 2019 rule. But that's the way it is now. You have a different set of rules starting 2020 forward. And a lot of people think, okay, so I put that in my trust. No, that is not in your trust. That is not in your will, and that doesn't pass by those things. They pass by beneficiary designation, kind of like an annuity or life insurance policy passes by beneficiary designation, and it's subject to estate tax. So
So
that
you're
value
saying
of
you're
that becomes
saying
the
that
estate
if
tax.
I have a qualified plan, for example, if I have a 401k with Schwab, you're saying that's between me and Schwab to set the beneficiary designation on that account, and that's
Well,
not something to include in my estate plan.
so usually I will coordinate those beneficiary designations with my clients' financial planners,
Okay.
because I mean sometimes it depends on the client profile and what's going on with that client. And like I said, here's the difficult one. I'm married. It's my second wife. I've got a large qualified plan. I want my second wife to be able to get some benefit of it while she's alive, because I don't want her to not be able to pay her bills. And what if she gets, cancer or something, and we have all these expenses? Um, so I want my wife to have the benefit of it. But whatever's not used when she dies, I want that to go to my kids. Well, probably not going to happen uh, under most circumstances. Under some circumstances it can, and so you got to put those circumstances in place. You've got to make that happen. But this is a big wake up call. A lot of times, and they find out that things didn't work out the way that they hoped it would. And we've seen where that $2 million IRA then goes to the step kid that the father didn't have any relationship with, really, to speak of. I've seen a case where mom's estranged child hadn't talked to her mom in over 20 years, got all of the husband's qualified plan, and the husband's kids got none of it. I've seen that happen, and that's a possibility. So that's a different set of estate planning issues that you need to talk to your attorney about and work that out.
Okay, well, to close here, Wit, I found this Mark Twain quote that I've always enjoyed, and I think it's pretty relevant to our discussion today. It goes, "It ain't so much the things that people don't know that makes trouble in this world, as it is the things that people know that ain't so." And so that's the problem with estate planning is you think you might know how it works, but odds are you probably don't, considering most estate planning attorneys, well, I wouldn't say most, but some percentage of estate planning attorneys aren't, even as competent as they say they are. That certainly suggests maybe we as consumers don't know nearly as much as we think we do. And how I think the conversation today has made it clear how that can create some pretty unfortunate circumstances.
Yeah, it's kind of like going back to what I said. A clients walk in my office and they say, "Here's my estate plan. Someone drafted this for us 7 years ago. Tell us how it works." And I said, "Well, what did you tell your lawyer to draft?" And they said, "Oh, we didn't tell them anything. We gave them some information." And really, you should be the one saying, "Here's how I want it to work." And so this is how it should work. You walk in, your attorney says, "What do you want to be the end result?" All right. Now, tell me where you are now, and I'll draft a plan that gets you to that end result. And that's the estate plan lawyer that you want.
Thank you so much to all of our listeners for tuning in. It's been a great conversation. We hope you found it as enlightening as we did. If you enjoyed today's episode, please subscribe to TaxWit's Wealth Protection Podcast on YouTube and Spotify. And if you have a question, feel free to leave it in the YouTube comments. Don't forget to check out the show notes for links to resources mentioned in today's episode. You can find those on Whitney's website at sorrell-lawgroup.com. That's SORRELL-LAWGROUP.com. Twice a month, Whitney and I will be discussing other exciting topics that you won't want to miss. But for now, it's time to say goodbye. Until next time, this is your co-host, Benji Albrecht, signing off. Take care and keep building that wealth the smart and legal way.